So this is a presentation of a paper that is forthcoming in the European Review of Private Law. It is a rather long article that Hada and I have tried to summarize here, but if you have any questions, please feel free to contact either Rada or me. So the title of our paper is Contractual Performance in COVID-19 Times, Does Anglo-French Legal History Repeat Itself? So the COVID-19 pandemic has given rise to a public health emergency, which led to economic turmoil that world leaders have compared to the aftermath of World War II. National government implemented different measures in an attempt to curtail the pandemic and support the economy. And while contract law is rarely the focus of public concern, it should be noted that because of the nature of COVID-19, we know that it might have long-lasting repercussions for the performance of contract that is very much at the heart of everyday life. So that's why we have decided, Hada and I, to consider this, the impact of COVID-19 on the performance of this contractual obligation whenever this execution of obligation have become difficult, impossible, or illegal due to the public health emergency or any measures imposed by the government. So in our study, in our comparative study, we look at the likely effects of the COVID-19 emergency on the performance of contract in two jurisdictions with distinct paths of development, so England and France. The purpose of our comparison is to show three things. The first one, to show that legal cultural disparities, which have historical roots, persist even during a global crisis, which has affected this jurisdiction in similar ways. The second thing is to consider if these countries have drawn from their own legal history in seeking to find solutions which balance freedom of contract and fairness. And the third thing is to analyze if one of either jurisdiction has better suited solutions to the challenges posed by COVID-19 to contractual performance. As we will explain to you, France, unlike England, has a long record of legislative intervention in contract law during challenging times, such as war. And what is interesting is that France has remained committed to this legislative intervention during the period of COVID-19. However, the novelty, as we will mention later on again, is that the government has intervened at the onset of the emergency, when in fact the disastrous impact of the crisis were not yet palpable. So meanwhile, as we will also discuss later on, is that in contrast to English contract law, which has doctrines with limited scopes, French contract law, in theory, disposes of quite a wide array of tools that could be perceived as better geared tools that can apply to supervening events like the COVID-19 pandemic. But there are issues to that. So I will let Rada just now expose the historical perspective to contractual performance in times of crisis.
Thank you very much, Catherine. Global leaders have compared the impact of COVID-19 to the aftermath of wars, and we thought this was an invitation to explore the historic responses by England and France to challenging circumstances. And so we noted that in both England, or the UK at large, and France, wars provided an impetus for the development of doctrines in private law, but also these wars forced legislators to intervene. So in both both England and France, we observe interventions. It's just that the French legislator is more eager to intervene, and his intervention has usually a larger scope. So this is a particularity we have observed. Now, when it comes to World War I, in France, it was quickly felt that the doctrine of force majeure, which is one of the signature doctrines of French contract law, was inadequate to address the needs of challenge performance or difficult performance because of war. It has a criteria of application that are difficult to satisfy, but also its effect is suspensive. So once the force majeure event is over, parties still had to perform. In addition, French judges are traditionally reluctant to recognize, or rather before the reform of 2016, French judges were reluctant to recognize the notion of imprévision or hardship as understood in French law for civil contracts. So it is from this perspective that we better understand why the French legislator intervened. The most known piece of legislation from the Great War is the Loi Fayot, which allowed the judge to terminate or suspend a contract upon the request of either party when certain conditions were met. Now, on the English end, and of course, I also wanted to mention this, that the French legislator also enacted various pieces of legislation aimed at price adjustment. So this is really interesting from a comparative perspective. Now, in England, the legislator also intervened. The two pieces of legislation that are most characteristic are the Courts Emergency Powers Act of 1914 and the Courts Emergency Powers Act of 1917. Now, the first act is interesting because it focuses on difficulties of payment. So courts could defer the execution of judgments and orders for the payment or recovery of a sum of money because of difficulties attributable to war for a time and under conditions the court saw fit. So these are wide-ranging powers from an English perspective. The 1917 legislation is even more atypical from an English perspective because it allowed courts to suspend or annul building contracts because of serious hardship that could be attributable to war. It also allowed courts to suspend or annul contracts whose performance had become seriously difficult as a result of government intervention in light of the war. And even though these powers are wide-ranging and really atypical, they were interpreted narrowly. So this may explain why parties were tempted to seek relief under common law doctrines, and at the time the relevant doctrine, and even in the current time the relevant doctrine to supervening events is frustration. Back in the day it was underdeveloped, and so World War I provided an impetus for developing of the doctrine. Still, while the courts allowed its application, the cases we observed, frustration was directly tied to illegality. Judges were reluctant to recognize frustration in cases of commercial impracticability or hardship as we understand it today. Now, in World War II, the two jurisdictions stayed faithful to their cultural heritage. In France, the legislator also intervened. We have a piece of a legislation that is very similar in spirit, but wider in scope to the Loi Fayot. So this is important, staying true to historic roots. We also saw diverse laws allowing for contract modification or price adjustments that are relevant. In England, the legislator was more tame compared to his intervention in World War I. We have the Courts Emergency Powers Act of 1939 that revived the spirit of the 1914 Act. Meanwhile, many parties were left at the mercy of the common law. So World War II provided the next impetus for the development of the doctrine of frustration, but it seems that judges were even more reluctant to apply it compared to World War I. So this is interesting. We also saw that some judges like Lord Denning were creative. So he carved out a smart exit in High Trees, a case in which he re-articulated the notion of promissory estoppel, or promise that could be enforced even if it's not supported by consideration under certain conditions. And so it is from this perspective that we have evaluated the current state of affairs, and we see that the French legislator has been faithful to the French cultural heritage, and so we see an intervention of a rather large scale that you would elaborate on in a little bit, while in England, the legislator, or in the UK at large, hasn't interfered in commercial contracts yet. So back to you.
Thank you, Rada. So as Rada mentioned, so this divide between the French approach and the English approach with respect to the legislative intervention has persisted even in the context of the COVID-19 crisis. And this is what has really caught our attention. So what is interesting is that now in France, contracting parties can benefit from a mix of government intervention and contract law solution. And by contrast, in England, in fact, parties will mainly rely on private law solution. And as discussed already mentioned by Rada, the doctrine of frustration that will be expanded later on. So first of all, we look at this intervention in the state intervention in France with respect to the COVID-19 pandemic. So we say that it's quite a messy state intervention. Just the idea that, in fact, the French government has issued 27 ordonnances to deal with some effects of the COVID-19 public health emergency can already be quite puzzling. But so in our case, we're not going to study all of them to your relief, but we're going to look at the ordinance of 25th March 2020 that adopted measures that were supposed to alleviate the drastic consequences which the crisis may have on contractual performance. So at first glance, French legislators seemed quite committed to interventionism, which had been drawn from the past, as explained earlier. But there are still some important differences. The first one is that these measures have been put forward at the onset of the crisis rather than at the time its effects were felt, which may be taken as a sign that French legislators have drawn from their prior experience, as discussed, mentioned by Hada earlier. On the other hand, what is striking about all these ordinances and measures is that they seem to lack a certain degree of clarity. And that might be different from the legislation that were issued during World War I and World War II. So just a few words about this ordinance of 25th March 2020. So Article 4 provides that late performance penalties, penalty clauses, termination clauses, and forfeiture clauses are deemed not to have come into force or effect insofar as, first thing, the purpose of these terms is to impose liability for the non-performance of an obligation within a specified period of time, and the period available to the promisor to perform its obligation expires between the 12th March 2020 and 23rd 2020 included. So already, without going any further, Article 4 confusingly distinguishes between different hypotheses as to the date when, in fact, these contractual terms may come into effect. So Article 4 raises issues in its implementation with respect to the timing. And that's something that is explored in our article. There are also problems relating to the wording and the coherence of the ordinance that creates some issues with respect to the interpretation whether in fact the specific, the scope of application of this ordinance only targets specific clauses whose purpose is to impose liability for non-performance. So does it include terms with any other purpose? And that's a question that we explore later on. So we're not going to look at the other ordinances, but what we, a study of this ordinance gave us a sense that they were quite patchy with very specific and limited scopes, and that they were leaving the contracting parties to their own fate and subjecting them to the ultimate discretion of the judge in their application. So contract law, in fact, have proven fairly immune to governmental attempts to find solution to these contractual challenges. So what is left? In fact, what is left is existing general contract law. So that's why it is necessary, and this is what we've done in our paper, it is necessary to find this, to consider this private law solution. So already, you can already, as a caveat, you can say that most commercial contracts have, in fact, inserted force majeure or hardship clauses, which allow parties to define the supervening events and their effects on their agreements themselves. But in the absence of such clauses, or when these terms are ambiguous, French contract law has clearly defined statutory provisions, which may be in fact relevant in the light of the COVID-19 emergency. Which one are they? So they are the force majeure provision, the hardship provision, and also in fact other provisions that now form part of what we call the contractual toolbox that is available to the parties. So very quickly, so let's say a few words about each of these doctrines or these provisions. So the force majeure provision, as already Hada has already mentioned, is one of the signature doctrines of the French contract law, but its application criteria are still subject to dispute. And here because of this time constraint, we won't be able to get into the details of this criteria. But what we can say is that because the criteria needs to be strictly applied by the court and have been strictly applied by the court, they are difficult to satisfy, and they are always assessed on a case-by-case basis in light of the facts of each case. And it seems very difficult that in the context of the pandemic, this force majeure doctrine will be quite well placed to adequately address the challenges of performance. So we have to set it aside. So now we have to consider the other doctrine that is available, which is the doctrine of hardship. And the 2016 reform of the French law of obligation has incorporated this doctrine of hardship in the civil code. But similarly to the doctrine of force majeure, once again, the strict condition of application of the new Article 1195 limits its reach in the context of the COVID-19 epidemic. And once again, I can't go into the details here, but I will invite you to read the paper itself. But just as a very quick mention, I would say that Article 1195 only applies to contracts concluded after the 1st October 2016. So any contracts concluded before that date are still subject to this well-anchored rejection of imprévision set in the 19th century case law. And the other point I will make is that because this article is not mandatory, it is quite likely that sophisticated commercial contract would have excluded the application of this article. So really what is left, for this article 1195 is quite a very small room or small area. So overall, when you look at the application of this article, once again, as with the force majeure doctrine, it will be judged on a case-by-case basis. And it is quite likely that courts will interpret interpret this article quite narrowly. So what is left about what is left now? In fact, what is interesting is that the 2016 reform of the law of contract has enshrined a section on contractual non-performance that sets out a list of remedies that are available to the aggrieved party. And once again, I don't have much time to discuss some of these remedies, but usually it's a series of unilateral prerogatives which allow the aggrieved party to deal with the consequences of contractual non-performance without involving the court. So one example is this Article 1226 that enshrines the unilateral termination of the contract by notice when the non-performance is sufficiently serious. So that's, you see, a new tool that is available to the aggrieved party. And so in that sense, that's something that could be more relevant to the parties in the context of the COVID-19 pandemic than the well-known, well-established doctrines of force majeure and maybe also quite this new doctrine of hardship. So overall, what we know is that there are some tools available to the parties. How they will use them, it's still, a question mark. To you, Rada.
Thank you very much, Catherine. Indeed, at first glance, parties contracting under French law have so many more options than parties contracting under English law. However, it's often forgotten that freedom of contract is one of the most powerful tools to combat injustice in English contract law. And it's because of the limited scope of the doctrine of frustration that English parties have developed the habit of including detailed clauses that consider supervening events, such as force majeure clauses or hardship clauses or material adverse change clauses. So it may be the case that a lot of parties, especially experienced parties, have already provided for the consequences of events such as COVID in their contract. And we've seen recent case law where we've seen courts analyze force majeure clauses where pandemics were explicitly mentioned. So this may give some hope. In addition, we know that English contracts, it's a cliche, but in fact, we've seen it in practice, are much longer than contracts under civilian systems, and so there may be other clauses that provide options for parties, such as early termination clauses, etc. So there may be solutions that are already in an existing contract. Now, parties may also be tempted to renegotiate their contract, and this was actually the practice back in the day, even in challenging times. World War I and World War II showcase some cases that were resolved in this matter. And it is from this perspective that the doctrine of consideration becomes quite relevant. And what is interesting is that it's quite versatile, and it could be interpreted in different ways depending on context. And here you and I immediately remembered Rolfe Brothers, where consideration was evaluated as a matter of practical benefit. So this may be an interpretation that could be helpful to address instances of difficult performance in COVID-19 times. Last but not least, and this is sad, that despite the development it has seen, frustration appears ill-suited to address the challenges for contract posed by the COVID-19 pandemic. It's very messy and it has a very narrow scope. In addition, it has draconian, drastic consequences because it entails automatic termination at the time frustration occurs. So this may have potentially disastrous effects for parties. Now, we don't have much time as we established, but just to briefly mention the criteria of application that may be considered, and this is part of the enigma here, that depending on context, judges prioritize different criteria. So it may be difficult to navigate the frustration landscape of the common law. But judges are concerned about foreseeability. Has the event been foreseen in the contract, or did parties foresee the event? Can one deduce that the event was foreseen based on the surrounding circumstances, based on the knowledge, expectations of the parties? Judges would also examine if frustration was self-induced or the equivalent of no-faulting requirement, as we understand it in civil law. And unfortunately, well, depending on whose side you're on, but we've seen case law in which this requirement was interpreted very narrowly. So this makes the application of the doctrine even more difficult and narrow. And last but not least, the last requirement is the radical change of obligation, or the contemporary test of frustration established by Lord Radcliffe in Davis Contractors. And maybe this is the hardest one to satisfy. And we've seen many cases in which judges overtly said that it is this requirement that reminds them that the doctrine should not be invoked lightly. And we haven't identified a case in which it was applied to a case of commercial impracticability or hardship as we understand it in modern times. So in other words, parties contracting under English law are better placed, or they can be recommended to attempt at least to find solutions themselves away from the courtroom. But we have the same recommendation for parties contracting under French law, and I know you have strong feelings about this, so I'll let you conclude.
Thank you, Rada. Yes, thank you very much for showing the this limitation of these traditional judicial remedies under English law. But what we have tried to show in this paper is that France and England, in fact, have stayed true to their historical responses, you know, vis-à-vis the effects of challenging times on contractual performance. And we've seen that France has a long tradition of state intervention in the name of fairness in contract, but that England, as you mentioned, in fact, usually leaves the difficult choices to the parties, and also mainly to the courts that have developed, you know, so some common law doctrines and equitable solution that were developed over time. So what we've seen some of these contractual tools that France have also tried to you know, set up or define, but overall what we can sense and what we have tried to demonstrate is that all these tools are in fact quite ill-suited to address these challenges in times of crisis, and that we need to find more creative alternative responses. And as you have already mentioned, we feel that parties have to move away from the courts. They have to not to rely on the courts themselves, and find the, you know, the solution that is adapted, that is suited to their needs. And how can they do that is through collaboration and solidarity between actors. So in a sense, we can see, and maybe the question we raise is whether there will be an evolution of the values of the English and French business communities as a result of the COVID-19 crisis. So we are yet to see that. So thank you very much for your attention.
Thank you very much. And we leave the question open for our listeners too. So please read our paper in case you're interested.
Thank you. Bye.
Bye.